Hey all, Richard Seller here, video update, another video blog. I think I want to call this one, Don't Be That Client. So we all hear horror stories, and you've heard them and seen them in the news about lawyers who, they don't call their clients back, or the lawyers disappear, or they steal the client's money and disappear. And yet we've all heard the lawyer stories. But having done this for 20 years, we've also seen, and by the way, I'm grateful for all of our clients, just disclaimer here, but we've also seen situations where clients could at times have unrealistic expectations of how the legal process works and how long things can actually take. So when I sat down to think about this particular video blog, I said to myself, let me identify some things that make it difficult for the lawyer to, as Jerry Maguire would say, help me help you. So reasonable time expectations is something that's real important from the beginning of the relationship. So for example, when you sign up with our firm, we generally send you a video of this ugly face saying, hey, thanks for picking our firm. Here's what's going to happen next. Give us about 4 to 6 weeks. And you might say, well, 4 to 6 weeks, my house is on fire here. I like to say that nothing good in the practice of law ever happens when it's rushed. Okay, so what generally happens, for example, in our practice is once you agree to retain our firm, from there, my pre-suit team will then commence what we call our pre-suit investigation. What does that involve? It involves us, for example, doing some research on your former employer to see if they've been sued before, do a little bit of research to see if other claims have been filed, do a little research on the finances of the company to make sure they're viable before you spend all this time and effort chasing a company that may file for bankruptcy. What we've seen in this microwave society that I call, everybody wants everything now, is that clients want to rush that process and just get something haphazard out. And that's not the way we practice, but some firms may be willing to just send out some half-baked product just to appease the client, but that's not in our client's best interest, and that's generally just not how we practice law. So the first bullet, if I'll give you, is be realistic in terms of expectations. Once the lawyer does their investigation, they'll prepare a letter on behalf of the client, or it could be a complaint or a lawsuit to be filed, okay? Now, negotiations take time, and the example I'll give is that over Christmas, most defense lawyers, meaning the employment lawyers on the other side, will go away for holidays and spend time with their family, and it's impossible to get somebody to respond to an email or to a phone call. And that's frustrating for a lot of our clients because even though we're here working, we're not able to push their file or do anything for them because the other side's not available. Now, as much as lawyers on this side of the fence, meaning us, fight for your rights, that doesn't mean we have to be mean or nasty or unprofessional or condescending to the other side or not afford them common courtesies such as, hey, my kid is sick, can I have 2 weeks to respond to your letter? If we say no to that, we look unreasonable, we look unprofessional. So while we're here to advocate for your rights, okay, we're not here to be jerks unnecessarily to the other side. We're aggressive and we fight for our clients, but we also try to maintain a professional and collegial relationship with the people on the other side of the fence. You know, the people we're asking to pay you money. So bullet point number 2, don't ask us to be mean to the other side just for the sake of being mean. It doesn't help your case, it actually hurts it. 3, litigation takes time. And the expression I always use is it's a marathon, not a sprint. Some cases can turn over really quickly. We've had cases that settled in 2 weeks, and we just went to trial on a case that was in our firm in full-blown litigation for 4.5 years. Every case, like a snowflake, is different, which means when you get involved in this process, although it's ideal to get you a quick resolution and get you paid, you have to be prepared for the long run. So what can you do as a client during litigation to, quote, not be that client? The first thing is make yourself available to us, your lawyers. There's nothing more frustrating than being in the middle of litigation and needing information from a client, such as documents or answers to questions, and the client's voicemail is full, or the client's not responding to emails. Again, help me help you. If I can't get in touch with you and you disappear for months at a time, at some point we have no choice but to close your file and you lose the case because we can't do anything without the consent and agreement of our client. So to not be that client, stay in touch with your lawyer. Number two, if you ask a client, or if you're a client and you ask your lawyer a question, give them a reasonable time to respond. Folks, we're in depositions and mediations and hearings all day on your cases, okay? So if you send your lawyer an email or say, hey, can I get a phone call? What's a reasonable turnaround time? I would say 24 to 48 hours. Of course, we try to and we strive to be much more responsive. And email is great because even if we're in a hearing or in a meeting, we can fire off a quick email to at least set up a call. But we've seen clients over the years whose expectations are, right here, right now, or I'm going to file a complaint or I'm firing you as a lawyer. I'll tell you that in 20 years of experience, when we get engaged or involved in a situation like that, we can already tell it's not going to be a right match. Remember, most of us are contingency-based lawyers, which means we don't get paid unless you get paid, okay? So we share every incentive that you do to expedite this process because we're spending our own time and money trying to fight for you with no guarantee of payment. So of course we want to get this resolved in the best manner and the most money for you, but you got to be patient with your lawyers. Go back to what I said earlier. Nothing great ever happens in the practice of law when it's rushed. Finally, communicate with your lawyers. Don't lie to your lawyers. We need to know where the proverbial bodies are buried. We need to know the good, but we also need to know the bad. We recently had a case on behalf of an executive who assured us that everything he was saying was true, that he didn't engage in the conduct that he said he engaged in, which resulted in his firing. He had told us he had been fired for being a whistleblower. Lo and behold, as we're getting ready to take depositions in the case, he brings us a bunch of text messages and he says, oh yeah, I forgot to tell you about these. And in these text messages, which were completely damaging to his case, it showed that he had not only lied to us, but he had lied to the other side, and that his firing was actually legitimate. He had done some pretty bad stuff. So we can deal with bad information on your cases. What we can't deal with in the spare of the moment is surprises on documents that you either hid from us or didn't tell us about. Don't be that client. Finally, in terms of settlement, I want to go back to one last point. Our job is to maximize the value of your case, okay? Now, we cannot force the other side, unless we go there with a hammer and start smashing fingers, to pay you exactly what you want or more than what they're willing to offer, okay? All we can do is put your best foot forward, advocate on your behalf, articulate your best arguments, and push them to the top settlement value that we can get. If they don't get to what we believe is a reasonable value, well, that's what a jury's for. And we go to trial. We go to trial, I would say on average 2 to 3 times a month at this firm. Not a month. 2 to 3 times a quarter at this firm. Misspoke, sorry. So there's avenues. If you don't want to accept the settlement, understand we can't force them to offer you more other than through fighting for you and being an advocate. If you don't want to accept the settlement, remember, we're not the ones that are offering it, they are. We'll go to trial, and we're happy to do that. But oftentimes, clients can have a tendency to take it out on the person that's trying to help them, us, the lawyers. I'm not crying poor me. We love our clients. We love what we do. The point of this is, don't be that client. Remember that we're on your team. We're here to fight for you. Have reasonable expectations of your lawyers, of time frames. Be honest. Be honest with yourself in terms of the good and the bad of your case. And at the end of the day, listen, you hired us, you hired a lawyer because we purport to be an expert there to try to help you. If you don't trust us, if you don't believe us, you need to go find another lawyer because you never want to be in a situation where you don't think your lawyer is looking out for your best interests. Okay, hopefully I didn't insult anybody and nobody's offended. These are just things you can do as a client to increase the value of your case, to be honest, to help us push your case forward. I hope this was informative. I'm looking forward to fighting for all of you. Of course, if you have any questions, email us, richard@floridaovertimelawyer.com. You're watching this video, go watch some other ones. Go online, check out our website, www.floridaovertimelawyer.com. We're here for you. We want to help you. And remember, don't be that client. Have a great day, guys. Talk to you soon.